can I ask you about a different precedent, about what we said in Buckley, and this picks up on the Chief Justice's earlier comment about government intervention because of the power of the social media companies. And it seems like in Buckley, in 1976, in a really important sentence in our First Amendment jurisprudence, we said that the concept that the government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment, end quote. And that seems to be what you responded with to the Chief Justice. And then in Tornillo, the court went on at great length as well about the power of then newspapers. And the court said they recognized the argument about vast changes that place in a few hands the power to inform the American people and shape public opinion, and that had led to abuses of bias and manipulation. The court accepted all that, but still said that wasn't good enough to allow some kind of government-mandated fairness, right of reply or anything. So how do you deal with those two principles?
Sure, Justice Kavanaugh. Well, first of all, if you agree with me with our frontline position that what is being regulated here is conduct, not speech, I don't think you get into interests and scrutiny and all that. I do think that the law advances the First Amendment interest that I mentioned, but I think that interest, the interest that our law is serving, if you did get to a point in the analysis that required consideration of those interests, our interest—
Do you agree, then, if speech is involved, that those cases mean that you lose?
No, I don't agree with that. And the reason I don't agree with that is because the interests that our laws serve are legitimate. And it's hard because different parts of the law serve different interests. But I think the one that sounds in your concern that is most directly implicated would be the hosting requirement applicable to journalistic enterprises. So one provision of the law says that the platforms cannot censor, shadow ban, or deplatform journalistic enterprises based on the content of their publication or broadcast. And that serves an interest very similar to the interest that this Court recognized as legitimate in Turner when Congress imposed on cable operators a must-carry obligation for broadcasters. And just as a broadcaster, in what the Court said was there was not just a legitimate interest in promoting the free dissemination of ideas through broadcasting, but it was indeed a compelling interest, a highly compelling interest. And so I think the journalistic enterprise provision serves that very similar interest. But there are also other interests that our law serves. For example, the consistency provision, Your Honor, is really a consumer protection measure. It's sort of orthogonal to all that. The consistency provision, which is really the heart of our law, just says to the platforms, apply your content moderation policies consistently. Have whatever policies you want, but just apply them consistently.
Because the government applies such a policy to publishing houses and printing presses and movie theaters about what they show, bookstores, newsstands. In other words, be consistent in what kinds of content you exclude. Could that be done?
I don't think so, Your Honor.
And why not?
Well, I think that there is the consumer here. The social media platforms, their terms of service, their content moderation policies are really part of the terms under which they are offering their service to users. I don't think that really that paradigm really fits in what Your Honor is talking about. But look, we agree. We certainly agree that a newspaper, a book, and a bookstore is engaging in inherently expressive conduct. And our whole point is that these social media platforms are not like those. And